Welcome to the City Club of Cleveland, America's citadel of free speech for over a century. My name is Sanjeev Kapoor, and I am a past president of the City Club. Earlier this month, Essie Mae Washington Williams died at the age of 87. Miss Washington Williams had a few years earlier revealed after the death of the late Senator Strom Thurmond that she was the biracial child of the senator who was at one time a champion of segregation. The senator in his youth had had a dalliance with an African-American maid in his parents' home. The story of Miss Washington Williams and the challenges of race relations in this country that it highlights is certainly not unique. In fact, our speaker wrote the following about the family of the first Justice John Marshall Harlan of the United States Supreme Court, about whom he will talk today. The Harlans conducted and thought of themselves as benevolent slave masters. The dissonance in that phrase mirrors other contradictions. James Harlan made it possible for several of his slaves to purchase their freedom, even as he bought and sold slaves in complicity with the slave trade. One slave who purchased his freedom was Robert Harlan, a light-skinned black who most historians agree was James Harlan's son and John Harlan's half-brother. Our speaker today, Justice Goodwin Liu, has himself faced some of the dissonance of race relations in America, albeit as an Asian American. When California Governor Jerry Brown nominated him to the Supreme Court of California at the young age of 40 in July 2011 to replace the only Latino justice of the California Supreme Court, the president of the Mexican-American Bar Association stated in anger to the Los Angeles Times, it should have been a Latino. When Justice Liu was growing up as a child, his immigrant parents from Taiwan, who were doctors to underserved poor areas, did not teach him English because they were afraid that he would speak with a Chinese accent. He only learned English upon entering kindergarten. Goodwin Liu has had a career that is marked by a love of education and education policy. He graduated Phi Beta Kappa from Stanford College. He had been accepted at several top medical schools and had originally planned to follow in the footsteps of his parents. But his plans changed after studying philosophy at Oxford University on a Rhodes Scholarship. He returned to the United States to work as a senior program officer for the Corporation for National Service that launched the AmeriCorps program. He thereafter went to law school at Yale, clerked on the D.C. Circuit Court of Appeals, and in a return to his interest in education policy, worked at the Department of Education, coordinating and developing K-12 education. That was followed by a clerkship with Justice Ginsburg at the United States Supreme Court, a stint at a large law firm in Washington, D.C., and a professorship at Bolt Law School at the University of California at Berkeley. He obtained tenure there in 2008, and in 2009 was awarded the top teaching award for the entire university. Justice Liu entered the national limelight when he was nominated by President Obama for a judgeship at the Ninth Circuit Court of Appeals. He did obtain the support of some prominent conservative lawyers, including Whitewater prosecutor Kenneth Starr, Clint Bolick of the Goldwater Institute, and Professor John Yoo, who is known for his memos supporting the legality of waterboarding. But Goodwin Liu had to withdraw his nomination in May of 2011 after his nomination failed to garner the 60 votes needed to force closure on a filibuster by Senate Republicans. In reporting about the hard-fought battle, Fox News noted, "Both sides agree he's a brilliant legal scholar at age 40. He could be a future Supreme Court nominee who could alter a thin conservative majority, depending on whom he might replace. That's one reason both sides lobbied hard to win the vote." Since assuming his role as the lone Democratic and fourth Asian American appointee on the seven-member California Supreme Court, Justice Liu has won accolades from the legal bar. In an article entitled "Liu's Put Together a Record of Restraint" that appeared this past December, a California legal publication noted, "In 15 months at the state's highest court, Liu is emerging as a brainy, independent thinker who nevertheless puts a premium on consensus and judicial restraint. The article does note that he is an outlier in one respect. Unlike the footnote-laden opinions of his colleagues, Justice Liu takes the view that if it's important to put in the opinion, you should put it in the text. So I guess no footnotes. On a personal note, you might be interested in knowing that Justice Liu is fluent in Spanish. He's a marathon runner and a tennis player, a master chef known among his friends for his famous salmon a la Goodwin, and an accomplished fisherman. One of his friends was quoted in a news article as saying, "To an unusual degree, he had no ego at all, a very humble guy. He's also, and I mean this in the nicest way, a little bit of a boring guy." Fishing is a passion, and what could be more boring than that? With apologies to the fishermen in the audience, please join me in welcoming the brilliant jurist but boring fisherman, Justice Goodwin Liu.
Thank you, Sanjeev, I think, for that generous introduction. It's a great honor for me to be here at the Cleveland City Club, a very humbling honor in light of others who have spoken at this podium before me. So thank you very much. And I'm grateful to your Executive Director, Jim Foster, for extending me the invitation. Well, since joining the California Supreme Court a year and a half ago, sometimes people ask me, who is my favorite justice? Or who are some of the judges I admire? And the short answer is that I admire all the judges who agree with me when I'm trying to decide a case. But actually, there are many judges I admire because there are many different qualities of judging that I admire. I would love to have the eloquence of Oliver Wendell Holmes, the insight of Benjamin Cardoso, the practical wisdom of Sandra Day O'Connor, the wit of Antonin Scalia, and the tenacity of Ruth Bader Ginsburg. But I suspect it would be difficult, if not somewhat unfair, for any one person to have all of these qualities, and of course, no one is perfect. So admiration of a judge or any human being beyond a superficial level has to be grounded in some deeper account of all of their qualities, the perfect ones and the imperfect ones, and that's sort of the tenor of my remarks today. There's a tendency, I think, in our discourse to be reductionist in our account of judges. By this, I mean a tendency to reduce the entirety of a judge's outlook or philosophy to a political ideology or a partisan agenda. Regrettably, I succumb to this tendency myself in some of my own commentaries about judges as a scholar before joining the bench, and it is a recurring dynamic of the modern confirmation process. Perhaps that is why, to take one recent example, almost everyone found it surprising and utterly unforeseeable that Chief Justice John Roberts would cast the decisive fifth vote to uphold the individual mandate in President Obama's healthcare legislation. That did not fit a certain set of political expectations held by the right and the left. Yet I would speculate that for most judges with a long career on the bench, such surprises and the resulting complexity are actually more characteristic of their approach to the law than strict adherence to any particular ideology. My talk today is intended to illustrate this point through a historical example, the life and work of Justice John Marshall Harlan. Now, some of the lawyers who are here will know that there were two John Marshall Harlans who served on the United States Supreme Court. One, appointed by President Eisenhower, served from 1955 to 1971. The other was his grandfather, who was appointed by President Hayes and served from 1877 to 1911. The subject of my talk today is the grandfather, the first Justice Harlan. My interest in Justice Harlan was piqued in law school, where first-year students in constitutional law read Plessy versus Ferguson, the 1896 case in which the Supreme Court, by a vote of 8-1, upheld the principle of separate but equal that would undergird state-sanctioned racial segregation for almost 60 years until Brown versus the Board of Education. Plessy is famous or infamous for endorsing separate but equal, but it is also famous for an eloquent dissent that declared in 4 simple words, "Our Constitution is colorblind." The author of that dissent was Justice Harlan. More than a century later, in 2007, the Supreme Court decided a case in which the question was not whether a school district can use race to segregate kids, but whether a district can use race to integrate its schools. And the answer, the court said, is generally no. What is striking is that Harlan's dissent in Plessy was mentioned 7 times across 4 separate opinions in that single case. And even more striking, 2 justices with virtually opposite views on race, Thurgood Marshall and Clarence Thomas, have both laid claim to Harlan's legacy. In that 2007 case, Justice Thomas wrote an opinion that invoked Harlan's famous words, "Our Constitution is colorblind," and he also quoted a contemporary of Thurgood Marshall who said that, quote, "Marshall had a Bible to which he turned during his most depressed moments. The Bible would be known in the legal community as the first Mr. Justice Harlan's dissent in Plessy versus Ferguson. No opinion buoyed Marshall more before Brown versus Board of Education." How could Justice Harlan be a hero to both Thurgood Marshall and Clarence Thomas on matters of race? How could his record be so celebrated yet so indefinite that it is invoked to support radically different legal views? And what was his vision for race relations and civil rights? These questions prompted me to take a closer look at Justice Harlan's life on and off the bench. And the contested nature, I think, of Harlan's legacy is a small reflection of the many contradictions in his 19th century experiences with race. Harlan's perspectives are more complex than any one sentence of his writings can capture, and we learn something along the way of what it means to be a great judge. So at one level, it is no mystery why Harlan so often ends up on the short list of admired Supreme Court justices. In addition to his lone dissent in the Plessy case, Harlan dissented alone in a set of cases in 1883 that struck down a federal ban on racial discrimination in public accommodations. He dissented in a case called Berea College versus Kentucky, which upheld a state ban on operating a racially integrated private college. He dissented in Lochner versus New York, a case that led to the invalidation of a wide range of state health and safety regulations. He dissented alone in United States versus E.C. Knight, a case that narrowly limited Congress's power to regulate interstate commerce. He dissented in the insular cases, where the court declined to extend constitutional rights to non-citizens in newly conquered U.S. territories. And he dissented alone in Hurtado versus California, one of several cases in which he argued that the 14th Amendment made the Bill of Rights applicable to the states. In these and other areas, Harlan's dissents have been largely vindicated in later cases decided by the United States Supreme Court. He is famous, to quote one historian, for his preternatural ability to articulate ideals inherent in the Constitution before the nation fully recognized them. Although Justice Holmes and Justice Brandeis were also famous for some of their dissents, Harlan, it might be said, inaugurated the tradition of the Great Dissent. But it is a mistake to portray Harlan as a legal prophet. The same justice who dissented in Plessy also authored the Supreme Court's opinion 3 years later in a case called Cumming versus Richmond County Board of Education, Cumming, C-U-M-M-I-N-G, a case upholding a Georgia school district's refusal to provide a high school for black children while providing one for white children. Harlan also joined the majority opinion in Pace versus Alabama, a case that upheld a statute punishing interracial adultery more severely than intra-racial adultery. Moreover, Harlan famously besmirched his dissent in Plessy by underscoring the injustice of segregation to blacks with the comment that even, quote, a Chinaman can ride in the same rail car with white citizens. Harlan also voted to uphold the race-based immigration policies in the notorious Chinese exclusion cases, and he voted against the court's decision in United States versus Wong Kim Ark, which upheld the birthright citizenship for a Chinese man born to non-citizen parents in the United States. So to understand Harlan, we have to see him not as some kind of mythic figure, but as a man who lived and struggled with the assumptions and contradictions of his times. And in so doing, we need not lessen our regard for Harlan. To the contrary, we might gain a fuller appreciation for why he deserves admiration. John Marshall Harlan was born in Kentucky in 1833. His father, James, named him after the great Chief Justice, John Marshall, not because he foresaw John's appointment to the Supreme Court, but because the family lived and breathed the tradition of Whig nationalism. Indeed, John had a brother named Henry Clay. His father, James, was a prominent lawyer and politician and held several elected positions in Kentucky. The Harlans were not plantation owners, but they owned about a dozen slaves. By all accounts, the slaves in the Harlan household were treated very well, even beyond their laboring years. John's wife, Malvina, who moved into the Harlan family from her home in Indiana, observed in her memoirs that the eldest slaves they owned, a husband and a wife into their 90s, were cared for like two babies. As Sanjeev said, the Harlans conducted and thought of themselves as benevolent slave masters. That's a very odd term to use, but it mirrors the contradictions that were inherent in the times that Harlan lived. Sanjeev mentioned that John Harlan had a half-brother, Robert Harlan, who most historians agree was James Harlan's son. And John Harlan never acknowledged his brother Robert as a family relation, but it is well documented that John and Robert remained friends and often collaborated in Republican politics throughout their lives. Robert, the brother, became wealthy in the California gold rush and had a successful business career in Cincinnati, thereby demonstrating that freed slaves could become productive citizens. Robert's very existence suggests that John Harlan was describing his contemporary reality and not predicting the future when he wrote in Plessy versus Ferguson that, quote, "The destinies of the two races in this country are indissolubly linked together." That Harlan would author the Plessy Dissent was hardly foreordained by his early professional life. Harlan went to Transylvania Law School in Lexington, where he became immersed in the nationalist ideology of George Washington, Alexander Hamilton, and his namesake, John Marshall. Upon graduating in 1853, he became a lawyer and an active participant in Whig politics. At the time, the National Whig Party faced increasing conflict over slavery, dividing into northern and southern camps. In Kentucky, the local party tried to appeal to pro- and anti-slavery factions with the theme of American nativism. Harlan joined the so-called Know Nothing movement, and during several political campaigns in the 1850s, he spoke prominently in defense of anti-foreign and anti-Catholic values. Harlan proved to be an extremely able orator, and he won election to a county judgeship at age 25. The next year, 1859, he ran for Congress as a Whig candidate. The main issue in the contest was, between him and his Democratic opponent, was slavery. And Harlan positioned himself as, quote, the more devoted defender of property rights in slaves. Harlan was staunchly opposed to abolition and believed the national government was obligated to respect the rights of slaveholders in the new territories. Although he lost that election, Harlan established himself as a key player in Kentucky politics. On the eve of the Civil War, with the erosion of any political middle ground, Harlan opposed secession and backed the Union cause. He joined the Union Army in 1861, and as a colonel, he led important missions in Kentucky, Mississippi, and Tennessee. By all accounts, Harlan was deeply affected by the war. In particular, the loyal service of Catholics and German immigrants in his regiment tempered his nativism, and his faith in the Union grew stronger. Harlan left the Army in 1863 and returned to Kentucky, where he was drafted by the Unionist Party to run for state attorney general. During his successful campaign, Harlan attacked President Lincoln's Emancipation Proclamation, making clear that the cause of preserving the Union was distinct from the cause of ending slavery. Lincoln had, in his words, perverted the character of the war, Harlan said, for the purpose of the war was, in Harlan's view, to maintain the Union and the Constitution, which was the only bond of that Union. It was for the high and noble purpose of asserting the binding authority of our laws over every part of this land. It was not for the purpose of giving freedom to the Negro. Harlan went on to argue several cases as Attorney General defending the rights of Kentucky slaveholders against federal interference. In the aftermath of the war, Harlan tried to carve a middle road between the radical Republicans and the Confederate Democrats, attacking both abolition and secession. He opposed the 13th Amendment on the ground that it violated the property rights of slaveholders loyal to the Union, and he opposed the 14th Amendment as an unwarranted revolution in our Republican system of government. But with the passage of these amendments, the Democratic backlash revived talk of secession and rebellion, and also took the form of extreme violence directed at pro-Union whites and blacks. And when these tactics delivered electoral victories to the Democrats, Harlan saw there was no constituency for a moderate third party in Kentucky, and at that point he cast his lot with the Republicans. As one biographer notes, quote, "The lynchings, floggings, robberies, and terrorizing which swept through Kentucky between 1868 and 1871, and the failure of the Democratic administration to control this, convinced Harlan that the only way to bring peace was to accept the results of the war, recognize the legal rights of the new freedmen, and end the reign of violence, even if it took federal intervention to do the job." As a Republican candidate for governor in 1871, Harlan gave a campaign speech declaring a change of heart on black civil rights. "It is true," he said, "that almost the entire people of Kentucky at one period in their history were opposed to freedom, citizenship, and suffrage of the colored race. It is true that I was at one time in my life opposed to conferring these privileges upon them. But," he said, "it seemed wise to the majority of the people of this nation not only to secure them their freedom in this way, but also to secure them the rights of citizenship and the rights of suffrage. And I am now thoroughly persuaded that the only mode by which the nation could liberate itself from the conflicts and passions engendered by the war was to pass these constitutional amendments. They are the irrevocable results of the war." And then he added, "Let it be said that I am right rather than consistent." Harlan's Democratic opponents spared no pains attacking his flip-flop on civil rights. They called him a, quote, "political weathercock," and reminded him of his earlier statements opposing the 13th and 14th Amendments. You can just imagine the kind of campaign ad that they would have run back then against him. Harlan lost the race for governor in 1871 and again in 1875, but by then he had become a major national figure in the Republican Party. With the election of Rutherford B. Hayes as president in 1876, Harlan was well positioned for an important appointment. He got the call on October 16, 1877, when Hayes sent his name to the United States Senate for confirmation as an Associate Justice of the Supreme Court. During his confirmation hearing, Harlan was opposed by skeptics of his recent conversion to the Republican Party and his belated allegiance to the Civil War amendments. Beyond his campaign speeches, Harlan did not have a long resume on civil rights. But whatever doubts his critics might have had, Justice Harlan was quick to dispel them upon joining the bench. Harlan's dissent in Plessy is his most celebrated. But the opinion in which Harlan apparently took greatest pride was his lone dissent in a set of cases in 1883. The question was whether Congress had power to enact the Civil Rights Act of 1875, which prohibited racial discrimination in public accommodations such as inns, theaters, and rail cars. This legislation was an early precursor to the Civil Rights Act of 1964. The Supreme Court held in 1883 that, quote, "it would be running the slavery argument into the ground to call such discrimination a badge or incident of slavery under the 13th Amendment." It further held that because the 14th Amendment applies only to state action, discrimination by private entities was beyond Congress's power to prohibit. Harlan's dissent in that case is remarkable for its expansive constitutional vision. To effectuate the 13th Amendment prohibition on slavery, he argued, Congress's power to enforce the new guarantee of freedom must be at least commensurate with its earlier power to enforce slavery. Before the war, the court had upheld Congress's power under the Fugitive Slave Clause to protect the rights of slave owners against contrary state laws. National authority to protect constitutional rights, Harlan said, quote, ought not now to be abandoned when the inquiry is not as to an implied power to protect the master's rights, but what Congress may do under powers expressly granted for the protection of freedom and the rights necessarily inhering in a state of freedom. In addition, Harlan said the 14th Amendment is not just a prohibition on discriminatory state action. Focusing on the first clause of the 14th Amendment, which reads, all persons born or naturalized in the United States are citizens of the United States and of the state wherein they reside. Harlan said that this citizenship clause was not a mere guarantee of legal status, but also a guarantee of membership in a political community known as the people of the United States. In other words, the citizenship clause of the Constitution literally constitutes the nation. Together, the 13th and 14th Amendments promised freedom, but not a condition of stateless liberty. They promised membership in a national political community. And one inherent component of citizenship, Harlan said, is, quote, exemption from race discrimination in respect of any civil right belonging to citizens of the white race in the same state. For Harlan, citizenship was central to understanding the meaning of constitutional equality. Interestingly, although citizenship expanded Harlan's vision of racial equality, it also limited his vision as well. His strong nationalism provides a window for understanding why he didn't have much sympathy for the immigrant plaintiffs in the Chinese exclusion cases. For people who were legally incorporated into the national community, Harlan vigorously opposed the racial caste system, or what we might call second-class citizenship. But for people outside of the national community, Harlan saw no reason why Congress should not have plenary power to set criteria for membership, even if the criteria were based on race. This nationalist view made it possible for Harlan to indulge the prevailing view that the Chinese were, quote, of a distinct race and religion, tenaciously adhering to the customs and usages of their own country, unfamiliar with our institutions, and apparently incapable of assimilating with our people. One can find no better statement of the myth of being perpetual foreigners that Asian Americans today continue to labor under. Yet within his national commitment, what do we make of cases like Pace versus Alabama, where Harlan voted to uphold harsher penalties for interracial adultery, and the Cumming case, where he wrote a unanimous opinion upholding separate and unequal educational opportunities for black children? How can these results be squared with his commitment to racial equality within the nationalist commitment? These challenge policies, after all, were part of the racial caste system every bit as much as the segregated rail cars in Plessy and the discriminatory inns and theaters in the 1883 civil rights cases. Well, one biographer has suggested that Harlan, though committed to racial equality, was also deeply committed to racial identity. In Plessy, Harlan famously wrote that, quote, every true man has pride of race. And he began the paragraph where he wrote, our Constitution is colorblind, by saying, quote, the white race deems itself to be the dominant race in this country, and so it is in prestige, in achievements, in education, in wealth, and in power. So I doubt not it will continue to be for all time if it remains true to its great heritage and holds fast to the principles of constitutional liberty. Harlan also hinted at racial identity when he said, 60 millions of whites are in no danger from the presence here of 8 millions of blacks. From this perspective, we see why Harlan might have refused to challenge the popular taboos against interracial sex and interracial schools. Harlan rejected the idea of de jure racial hierarchy, but he believed in the concepts of race and racial identity. Social contact between the races threatened to erode these concepts, and with them, the cultural categories and traditions that Harlan knew well from his Kentucky upbringing. Even at the time of Brown versus the Board of Education, schooling and marriage were closely associated as the ultimate zones in which many Americans would claim that racial separation was simply a way of life. But history has shown that racial separation and racial hierarchy are deeply intertwined, and in all likelihood, Harlan knew this too. Although Harlan spoke of racial identity in black and white terms in Plessy, he was intimately familiar with a more complex reality in the person of his half-brother, Robert. And although his opinion in the Cumming case does not acknowledge segregated schools to be a symbol of racial caste, Harlan was not unaware. At the end of his career, he listed several cases to be published in a book containing my opinions and dissenting opinions, and that list includes his dissents in Plessy, the 1883 civil rights case dissent, and other cases concerning black civil rights. It does not include his opinion in the Cumming case. Justice Harlan served on the United States Supreme Court for 34 years, the sixth longest tenure of all time. He began with colleagues who witnessed the Civil War. He ended with colleagues who would witness the New Deal. Along the way, he authored 772 opinions for or with the court and 137 dissents. In the final analysis, how do we measure his accomplishments? How do we take stock of this complex record? Well, Harlan was right about many things before a Supreme Court majority got it right, so it is tempting to describe Harlan as a legal prophet. But the label has two problems. First, it suggests that Harlan approached the issues of his time with a kind of mystic intuition or sixth sense, when in fact he applied lawyerly forms of textual and historical reasoning that were equally available to his colleagues on the bench. And second, to be labeled a prophet is to be held to an impossible standard. In many ways, Harlan's views fell short of our current notions of racial equality, but in reaching that conclusion, we have the benefit of a century's worth of experience that Harlan did not have. A better way to evaluate Harlan is to compare his record with the norms of his era. On some issues, notably Chinese immigration, Harlan's views were very 19th century. But on civil rights, Harlan's vision of racial equality was exceptional on the Supreme Court. It is true that his views generally reflected those of the radical Republican Congress. But unlike Charles Sumner, John Bingham, and Thaddeus Stevens, Harlan did not enjoy the support of his institutional colleagues. His dissents must have required some courage because he had no basis to foresee his ultimate vindication. Indeed, after Plessy, the nation lost interest in civil rights for the next 60 years. A 1953 edition of the Encyclopedia of American History included an entry on Harlan, but did not mention his civil rights dissents. Only after Brown versus the Board of Education was Harlan generally regarded as a great justice because of those dissents. An even more poignant measure is to compare Harlan's record with the norms of his own life experience. How was it possible to grow up in a slave-holding family and become the Supreme Court's foremost champion of black freedom? How did Harlan reconcile his earlier opposition to the Civil War amendments with the expansive interpretations of the amendments he rendered as a judge? And how did Harlan rationalize the mores and traditions of his upbringing with the compelling logic of his commitment to racial equality? The answers to these questions are, like Harlan's own record on civil rights, not always satisfying or complete. But one might say that Harlan traveled as far as could be expected of any person over the span of a single human life. Perhaps more than any single opinion or any specific utterance, it is the total arc of Harlan's life that is his real legacy. And it is a legacy that inspires faith that our nation and its laws can always become something more enduring and just. Thank you all very much.
Today at the City Club of Cleveland, we are listening to a Friday forum featuring the Honorable Goodwin Liu, Associate Justice for the Supreme Court of California. We will return to our speaker momentarily for the traditional City Club questions. Please formulate questions now and remember to be brief and to the point. We welcome all of you here and those listening to 90.3 WCPN Idea Stream, WCLV, WTAM, or one of the many radio stations across the country. Our television broadcast partner is WVIZ PBS Idea Stream. Television broadcasts of the City Club are made possible by Cleveland State University and PNC. Our live webcast is supported by the University of Akron. Closed captioning of our programs is made possible by the Nordson Corporation. We welcome guests today at tables hosted by Baker Hostetler, Case Western Reserve University School of Law, and Margaret Wong and Associates. Thank you for your support. Today we welcome students from John Adams High School, Holy Name High School, Horizon Science Academy, and Brush High School. Student participation in today's program is made possible by the Charles E. Spar Charitable Trust. Will the students please stand to be recognized? Now, we would like to return to our speaker for our traditional City Club question and answer period. We welcome questions from everyone, including guests. Holding the microphone today is Program Director Carrie Miller. First question, please.
Mr. Liu, when you were speaking about Justice Harlan, it brings to mind the fact that President Eisenhower did appoint his grandson, I guess, to be the justice in the 1950s. Now, it was rumored at that time that President Eisenhower was not too happy with some of the decisions of the Warren Court after he had appointed Justice Earl Warren. But the appointment of Justice Harlan might tend to believe otherwise. That and Justice Charles Evans Whitaker, frankly, I wasn't too familiar with either of them. But would you say that President Eisenhower was rather consistent in his choices?
Well, the story about Eisenhower and Earl Warren is a very interesting one. Eisenhower was known to be somewhat disappointed with the selection of Warren after Warren issued Brown versus the Board of Education, another decision. I think there's a quote in some of his biographies in which Eisenhower says that appointing Warren was the biggest damn fool mistake I've ever made. But to his credit, of course, Eisenhower, though disagreeing with Brown versus the Board of Education, enforced it. He was the one who sent troops to Little Rock, Arkansas, to integrate Central High School after the Cooper versus Aaron decision in 1958. So the rule of law, prevailed. John Marshall Harlan, the grandson, is an interesting justice in his own right, and very different from his grandfather. The biggest sort of jurisprudential point of difference, perhaps, and perhaps what the latter Harlan is most known for, is that the grandson staked out a very powerful view, and was much contested at the time, that the Bill of Rights was not incorporated as against the states. And this was a big theoretical debate in the academy and also played out in a number of decisions in the United States Supreme Court. His grandfather had taken the exact opposite view in a dissent in the Hurtado decision many years earlier. Jurisprudentially, they were also very different in terms of approach and style. John Marshall Harlan, the grandson, was, I think, most famous, is perhaps the justice in our sort of most latest contemporary period, most well known for being sort of a lawyer's lawyer, a judge's judge. Very strict, disciplined, very faithful to precedent, very narrow in his interpretations, although there are some exceptions. I mean, Harlan wrote expansively about the Due Process Clause. He believed that there was such a thing as substantive due process, which is a very contested notion. But by and large, he was a kind of stickler, very disciplined, and wasn't going to invent big new theories of constitutional law. And I think, the grandson was very respected as well for being an incredible colleague. Never a sharp word exchanged between him and people with whom he disagreed. I mean, he was writing many dissents in the Warren court because Warren and others took a much more expansive view of some of the subjects, including constitutional rights decisions, than Harlan ever would. But Harlan nonetheless was extremely well respected during this period, and indeed some of his dissents have become the law of the land.
Justice Liu, thank you for reminding us about the arc of experience. I'm an older retired attorney. I could never imagine in my young years as a lawyer that this country would come to the point where we are with judicial vacancies. And I wondered if you could enlighten us, lawyers and citizens alike, what can be done to see that these vacancies are filled? Well,
I tried. It's a very serious problem, but I think the unfortunate thing is I'm not sure it's a problem that captures the public's imagination. For insiders to this process, the confirmation process, people know all the numbers and they know, the impact. But to ordinary people who are going about their affairs in the world, I don't think they feel that they are deeply impacted by the vacancies on the federal judiciary. I would compare that, by the way, to vacancies on state judiciaries or the general decline in budgetary support that many state courts are facing today. Now there, I think the average person on the street faces some very serious problems because many of the more mundane matters, probate, family law, custody, divorce, whatever, end up in state court. And many of those things just aren't going to get the attention that they deserve, or not as fast as they deserve when the courts are shuttered. As to the bigger issue about the federal confirmation process, I mean, we have in the audience today people who are far more expert on it than I am. But I will tell you that I think it is inherently a political process. I think the Constitution of the United States was designed to make it a political process. And so, although we see a lot of fireworks about it, from a certain, constitutional perspective, I'm not sure that's a sign of dysfunction. The fact that people disagree about nominees, for whatever reason, I think is within the bounds of legitimate political debate. The problem, I think, is that the process has become transformed into requiring 60 votes for everything to happen instead of a bare majority. And that, I don't think, is part of the constitutional design. So whereas people, I think, are entitled to support or oppose a nominee for whatever reason they choose, that's a senatorial prerogative, I think people should actually vote. And they can, let the chips fall where they may, but they ought to vote. And, that is something that hopefully, there will be a middle ground in the Senate among senators who can agree on that basic proposition.
Mr. Liu, when I was researching, I came across the fact that you used to be a judge. Has there ever been a decision that you made as a judge that you thought may have been a mistake, or ever possibly changed your mind about a decision?
Well, I'll tell you, that's an excellent question. And I think it would be hubris to say that there's no decision on which, for any judge to say that there's no decision that you might not look back on and wonder, gee, might it not have come out the other way? I'll give you a different kind of answer to that question, which is that in my short time on the bench, it's only been a year and a half for me, I've encountered many issues that are close. I mean, really, they are close. And you don't really know that from reading the opinion because the form and sort of style of judicial writing is to make everything look okay. It's to make it all turn out right. I mean, if the judges aren't convinced of their position, why should the reader be, right? So it reads like the law is about continuity. It's about a rule. It's about, how what we do today connects to what happened before. That's why we have a rule of law. But you know what? That's a certain kind of that's a certain kind of ironing out of what are essentially very difficult legal problems. And most of my colleagues, I think, would agree that we see a lot of cases that are very close and could come out the other way. You have other competing concerns that help you sleep at night, which is that in many instances, parties and the affected entities, the citizenry, can actually live with one rule or the other in many cases. What people often need is clarity and certainty and finality with respect to the rule. That way they can arrange their affairs around the law, with the law, in concert with the law, or whatever, right? And so sometimes a higher premium, I mean, sitting on a state high court, we face this a lot, a quite serious premium must be put on reaching a decision and not simply kicking the can down the road on important questions on which people are depending on an answer, whatever the answer is. And so even if we occasionally get it wrong, hopefully we don't do it in a way that does serious damage to the ability of other people to essentially work around what we do. But one of the things that your question highlights is that courts, by their very nature, including ours as a court of last resort, have to be very, very cautious about exercising their power. We are a court of discretionary review. It is not a good idea for us always to review cases that look interesting because of the possibility that we might get it wrong. And that is always a possibility. And so the first principle in law and as in medicine is to do no harm. We have to be sure that what we're doing does no harm. And that, I think, informs a great deal of how we behave as a court and how we write as judges.
Justice Liu, you gave a persuasive explanation of Harlan's opinions from a political view as a Whig, Federalist turned Whig. My question is, given that there is a judicial tradition of involving morality and equity explicitly as part of the decision process back from Mansfield and Eldon and Story and Shaw that he was familiar with, given that there was a moral tradition outside the law about equality that goes back to Wilberforce and Mark Twain and Harriet Beecher Stowe and Frederick Douglass and others that he was familiar with, before we commend him, is there any sense at all from what you know of him that he had one whit of moral right about the basic opinions or about including what might be morally right or equitable or called for morally in a judicial opinion?
Well, the short answer is I don't know. I don't know. Haven't read enough to be able to truly answer your question. But I will say this. A person in his position is not a philosopher. That is not what judges are. Judges are not philosophers. And so there are lots of traditions of thinking out there about lots of different subjects. But judges are being asked to decide cases that are brought before them based on the materials that are actually before them, and they are not unaware of the overall context of the society in which they live. Harlan may have read all the people who you discuss, but the fact is that during the period in which he was staking out the positions he was, it was a very tumultuous time of transition in American history. The Civil War having ended, Reconstruction having started, but then being quickly brought to a close, the withdrawal of the Union presence from the South after the election of Hayes, that was part of the Hayes-Tilden Compromise. By the time of 1880, 1885, and certainly by the time of Plessy in 1896, one has to imagine that there was not a political groundswell or a political center in support of some of the things that he was talking about. Folks like Sumner and Bingham in the Congress were gradually being marginalized as the new settlement, of folks who would become sort of the turn-of-century legislators were beginning to take office. So, I'll leave it to each of you individually to decide what you think of Harlan. I've given you a little bit of his record, and you can decide what you want. It's a very mixed record. That's kind of the point, is that it's a mixed record. But I will say that I think that his views in some of these cases in the late 19th century were, I think, genuinely courageous, for their time. Because it's not that he could rest on philosophers or depend on some incoming political or anticipate some kind of political majority somehow coming in and vindicating his views. The three branches of government, I think, were quickly moving towards quite the opposite view of most of these issues, and it wouldn't change really for another half century.
Justice Liu, please help me reconcile two different views of the Enumerated Powers Clause.
I hope I can.
In the Federalist Papers, James Madison wrote, "The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite." Hamilton, also in the Federalist Papers, speaking about the fact that we didn't need a Bill of Rights, said, "Why declare that things shall not be done which there is no power to do?" On the other hand, the Supreme Court said in the wheat case that wheat grown by a farmer on his farm for his own use on that farm affected supply and demand and therefore affected interstate commerce. And in light of that, I can't think of any economic activity that doesn't affect supply and demand and therefore interstate commerce. And of course, recently we have Obamacare with its regulation of 18% of our economy. So on the one hand, it seems that we've got a view of the founders that the powers are very limited. On the other hand, I literally can't think of any economic activity that under the wheat case and Obamacare, the federal government couldn't regulate.
If I had the answer to that question, I would probably have written a book by now about it. That is the ongoing debate. You put it so well. That is the ongoing debate. That was the debate in the healthcare case. That's been the debate, I think, for the past at least recent period. In light of it's a constitutional debate. It's also a political debate. It's a debate about the size of government. It's a debate about the extent to which government can regulate people and what they do. And I suspect it will be a debate that is with us for some amount of time. Now, I think there are certain economic realities that have shifted the understandings of these words over time. If you go and read the early 20th century cases on the Commerce Clause, of course they will sound very different than the 20th century cases, later 20th century cases, that are dealing with the interconnections of an increasingly integrated national and international economy. And so it's a debated proposition, I think, among the scholars and even among the justices about whether older understandings that reflect original intent should be adhered to versus others who say that the words should be adapted to the problems of the age. Indeed, there are even people who have written that the original intent of the framers was to encompass things like the wheat and others. So I don't have a good answer for you, but I think that this debate is not over, and the healthcare decision that was issued just the other year only kind of deepens the intrigue in a certain way.
Justice Liu, you have been reflecting upon the legacy of Justice Harlan, not as an academic, but now as a sitting justice. What would you like your legacy to be as a justice, and what role will dissents play in that?
I can barely find my way to the courtroom. So I've only been in the job for a year and a half. It's far too early to be thinking about legacies. Sounds like I'm going to live a short life or something. You know, I really, I'll tell you this in all seriousness, that the biggest change for me in moving to the bench was having to think and write about lots of different areas of law that I had not specialized in or frankly hadn't picked up and read in a long time. That's the nature of the job of a judge, is to be a generalist, the consummate generalist. I mean, you take whatever comes in the inbox. I mean, we have some discretionary review, but nonetheless, it's a very broad range of things. As a scholar, of course, you have the great luxury of picking what you study and going very deep in those things. Don't have that anymore. So it's a very humbling experience. And so I think it's going to be some time yet before I am able to kind of see the forest and not just the trees. Right now, I'm still very deep in the trees. I mean, I really am. You know, it's every case one at a time, thinking hard about every case one at a time. And gradually, you think about these folks who we admire, Holmes, Brandeis, whatever. You know, they had very long careers, and they had a lot of time to reflect on lots and lots of cases and their own behavior in lots and lots of cases. I really just couldn't predict because there's so much yet to come. Thank you all very much.
Today, at the City Club of Cleveland, we have been listening to a Friday forum featuring the Honorable Goodwin Liu, Associate Justice for the Supreme Court of California. Thank you, Justice Liu. Thank you, ladies and gentlemen. This forum is now adjourned. Thank you very much.
For information on upcoming speakers or for podcasts of the City Club, go to cityclub.org.
PNC is proud to support the presentation of this City Club of Cleveland Friday Forum on WVIZ PBS.
Additional support comes from Cleveland State University. Support for closed caption transcripts of City Club forums is provided by the Nordson Corporation Foundation.